You're listening to Protecting What Matters by the Ohio Department of Commerce. Commerce is Ohio's chief regulator, and we play a vital role in keeping you safe by protecting your property, your money, and some of the products you use every day. This is designed to bring awareness to important issues and help educate consumers and businesses. Join us as we chat with trusted industry experts focused on providing you with the tools you need to help you protect what matters most in your life.
What we are doing is getting as much stakeholder feedback as we can, proposing what we think is fair, efficient, and expeditious, and hoping that with all of the feedback that we get, we propose something that industry wants, that we want as a regulator, which is a win-win.
Thank you for joining us for this episode of Protecting What Matters. I'm Michaela Hunt, Chief Communications Officer for the Ohio Department of Commerce. There has been a lot of interest in standing up the Division of Cannabis Control, and in this episode, which is posting early February 2024, we're talking about the rules package we are preparing to submit to the Common Sense Initiative, uncomplicating some of the legal language that we know many people will be interested in. Jim Canepa is the Superintendent of the Division of Cannabis Control, and Andrew McCoskey is the Chief Counsel for the division. They're joining me to break down everything you want to know. Hello, gentlemen. So what can people expect to see in this proposed rule package, Jim, and what are some of the more intricate parts that we can break down?
Really, there are three components: fees as they relate to patients and caregivers, fees as they relate to processors, and sort of a roadmap of how these bonus or 10B licenses will go out for non-medical dispensaries. And so as they relate to fees, it's currently $50 and what is it, $25?
Yeah, $25 for caregivers.
And then it's currently $100,000 for processors. We're eliminating the caregiver and the patient fees and reducing the processor to $50,000.
Can you define what is a 10B license really?
Sure. The initiated statute set up a system where licenses will be given out to certain specific entities. We call these 10B licenses because it comes from Section 10B of that law. But a 10B license is the bonus license or the gift license that is being granted to currently existing operators under the initiated statute. So under that scheme, a level 1 cultivator will get 3 dispensaries, a level 2 cultivator gets 1 dispensary, and every dispensary in the state will get an additional location. These are outside and different from the conversion to a dual-use license.
And we're going to dig into 10B a little more later in the episode. It'll be important to talk about that. I want to ask a couple questions about patients. So this fee change, does it apply to all patients and caregivers? It sounds like it does. And do you pay the first time you sign up, but after the first year you won't again? How does it all work?
So yes, it applies to all patients and all caregivers. And currently, the rule is going to go out. I think we have some plans on how to expedite the elimination of that fee as soon as we can. I think it relates to the timing of the rules and so forth, but we have some ideas about the timing on that.
Yeah, absolutely. I think that the big piece for the patient and caregivers is we wanted to try to provide immediate relief for patients who have been paying in this program for a while. We've done a good job of managing the finances of the program up to this point, and I think that we can expect that we can provide this relief kind of directly to patients. But we will apply this to everybody. No one will have to pay renewal fees, and as soon as we're able to roll that out, I think that we'll be able to allow the rules kind of catch up to that point as well.
Jim, why does remaining a patient in our medical program really benefit patients?
So I think that there's a number of reasons that a patient would want to stay. First of all, you have a recommendation from your doctor if you have medical conditions. Clearly, whether it's medication that's not cannabis, or even if it is cannabis, you really want to be in close touch and communication with your doctor as it relates to dose and frequency and those sorts of things. So there's that piece of it. There's a tax relief portion of it for those who are buying the still in the medical program with a medical with a medical card. And then there are, discounts that the dispensaries will give to medical patients that will benefit them. And finally, many employers are going to a policy that recognizes medical conditions and that the cannabis is a medical treatment for those sorts of things, including the state of Ohio. And so to the extent that that medical card provides them some grace as it relates to their employment, that's also a big benefit.
Let's talk the processor fee again. Andrew, it's a big cut in the processor fee. So how are we able to do that at Commerce and still have revenue to support the program and other projects that are indicated within the initiated statute?
Sure. So the processor fee is currently $100,000 per year, and we're trying to reduce that to $50,000. It does go back to, I think, that we've managed the finances of this program particularly well. We feel that the budget is in a place where we can provide this particular relief. And processors are in a unique position in the system where they have to receive product from the cultivators and have to sell it then down the chain to dispensaries. So being in that middleman role, having a higher fee and as it relates to the rest of the program, this is a proportional reduction showing sort of the market share that they have and the revenue that they sort of intake and outtake.
An important question for those who want to get into the business, when does this application period open?
So the application period by the initiated statute is no later than June 7th. What I'll add to that is right now, yes, public has an opportunity to weigh in. With that, though, what we're really looking for is feedback from players in the industry. And so before we get more into the formal CSI JCAR process, we're hoping to refine our plans, our roadmap, our proposals, taking into great consideration the feedback from stakeholders. Lots of conversations with the licensees at all level. It's been very informative, very helpful, and we've started to refine what we've proposed already based on a lot of that feedback.
We've asked people to submit responses by February 9th, but we also will have the ability to receive responses after that. There's going to be some time it takes to process those responses and then submit the final draft to CSI. And even during the CSI process, there's opportunities for the public to continue to weigh in. There will be a public hearing before any of these rules take effect. So there's opportunities for people to continue to have their voices heard.
Question on medical dispensaries. Do they get the first opportunity for non-medical sales?
Yes, the first chances will probably go to the dual-use licensees. One of the initiated statutes designs is that the existing medical dispensaries will get a dual-use license, meaning they can sell to both medical patients as well as adult-use consumers when the time comes for that. So they will have the first opportunity to convert their license from a medical-only to dual-use, and they should be the first ones through the gate. Everybody else with a new location will probably have to go through the application process, build out their facility, and there will be some delay in getting the new locations open.
Since we put out a press release about this and there was a phone number on it, got lots of calls on this next one, will there be prohibitions on businesses obtaining a license, such as if someone has a criminal record or they want to attempt to join with another business like a bakery?
Okay, so good question. Remember that this round is about 10B bonus licenses for existing licensees who have already gone through the process, which includes a background check. So the current businesses, the current licensees have already gone through that process. So what we're talking about here is getting a dual license that includes something other than their medical, the non-medical. Your question goes to new businesses who are interested down the road for a cannabis license at some level. And so the required background checks, those aren't going to change. Those are still going to be there. So all the people who are interested in licenses net new down the road have the same process to go through to be qualified to meet the requirements. As it relates to co-locating, it's not really are they prohibited to co-locate. The question really is can they meet the compliance requirements that are in place to manage, store, sell, and meet the compliance requirements for marijuana. And so right now those are very specific to meet. And so it's not totally out of the question.
But it'd be hard for a bakery to be able to do
It's not even whether
something.
it's hard, it's whether or not the business can meet those requirements. If they can, then that's what would be considered. But to the extent that there's a bakery or there's a hardware store or there's something else, the question isn't whether there are other aspects of a business, it's whether they can meet the core requirements of the cannabis license.
All right, a good initial introduction. Thanks, Jim and Andrew. A little later, we're going to dive into what comes after this first set of rules goes to CSI, if anything can impact the timeline, and any input the General Assembly might have. But up next, we'll go over the process of issuing licenses, really drilling down into specifics about how the process works.
Thanks for listening to Protecting What Matters from the Ohio Department of Commerce. We are your resource for all safety information for your home or business. Here's a quick safety message reminder from the Ohio State Fire Marshal's office.
So smoke alarms, we want to make sure we're putting those on each level of the house. Each bedroom that you're at, where anybody sleeps, put that inside that bedroom, and then outside where the people sleep. They're important because what you typically have is that early activation, early notification of something happening, in this case smoke building up, and that usually is what tells you that there's a fire happening. So having those placed in those locations that are appropriate, making sure that you're checking the alarms themselves about once a month just to make sure that they're working, change the batteries on them, we like to say twice a year right now, and then after 10 years, those entire alarms are going to need replaced.
For more information on the State Fire Marshal, visit our website at com.ohio.gov/fire.
Welcome back to this episode of Protecting What Matters. I'm Michaela Hunt for the Ohio Department of Commerce, and I'm joined by the Superintendent of the Division of Cannabis Control, Jim Canepa, and Chief Counsel for the division, Andrew McCoskey. Gentlemen, as we talked about at the top of the podcast, we know that this set of proposed rules really involves these three areas, the set that we're talking about right now. And one of those areas is the new application process. So can you talk a little bit more about what new licenses there will be and what that process will look like?
Let's start with the playing field here. There are existing licensees in the medical cannabis industry. There's the cultivators, the processors, and the dispensaries for purposes of this discussion. Of course, there are also labs, but they're not part of this discussion. So the cultivators and the dispensaries are existing medical licensees. In the initiated statute, the cultivators and dispensaries are given what is called a 10B license, because in the initiated statute, section 10B gives them an additional, a bonus, a gift, however you want to call it. We call it 10B. And so it prescribes how many additional ones they get, and so consequently how many we have to populate the map with. The existing cultivators and dispensaries all immediately will become dual licensees. So they'll be able to manage their business for medical and non-medical. Set that aside. The 10B licenses are additional bonus gifts for the cultivators and the dispensaries, which is the 10B process that we're proposing in the rule package.
Yeah, and the 10B licenses are divided by statute. The statute tells us how we need to divide these particular licenses up. In the statute, level 1 cultivators, which are the largest cultivators in the state, get 3 bonus gift 10B licenses, 10B dispensaries, I should say. The level 2 cultivators get 1 10B license, and every dispensary in the state gets a 10B license. There's an additional restriction, though, that says if you are a dispensary and you are affiliated through common ownership or control with one of the cultivating licenses or a processing license, then you do not get one of these 10B dispensaries as part of the initiated statute. So the state is going to go through all of the connections between these entities to determine what common ownership and control is, so that we can determine the number of licenses and the entities that are entitled to get them before we are issuing the application and start the phase 1 and phase 2 process, which we're going to talk about.
How will the process of issuing new dispensary licenses exactly work?
Well, exactly is ultimately to be determined if there are any changes through the formal process of CSI and JCAR. But we can give you what we've proposed and how we are hoping, at least in broad strokes that it goes. So let's start with a sort of a broad concept. There are really two phases. One is sort of an open destination phase with limitations. The second phase is a mapped, more prescribed destination phase. Both phases will be subject to a tiebreaker mechanism. Again, we talked about that rank of drafts ranking, like in fantasy football, right? So the lottery will determine you get pulled out of a hat, so to speak, a virtual hat, and you're ranked 1 through the total number of 10B licenses there are. And so if more than one person is giving us their open destination choice and they're within 1 mile of each other, we have to figure out and resolve that. So the higher rank from the lottery will bump others that are in that same 1 mile radius. So the higher ranking gets that location, they put their pin, we draw a map around it, we publish it. The others, if there's a second or a third or a fourth, get bumped to find another location. And if they're higher draft choice or rank choice, they may bump others that are in a 1 mile radius outside of that 1 mile radius. We're actually sort of hybridizing two phases. The first phase is that open destination idea where they have a lot of choice of where they can go with some limited or limitations. The limitations are what we call statutory objectors, which are schools, playgrounds, parks. The second is whether or not the locals opted out of having these licensees in that zone. And the third will be a 1 mile buffer around each location. Why the 1 mile buffer? A number of reasons. One is our experience in the industry and around the country is when they're right on top of each other, the failure rate is great. So for that reason, we're putting a 1 mile buffer. The other policy-driven reason is we really don't want an over-concentration in locations that they all want to be. So we don't want a cannabis row. We don't want over-concentration in particular areas that are, prime locations. So the 1 mile buffer will buffer those opportunities. Each dispensary that has one, and one of the 3 that each cultivator has, will be in that first round, and we're saying, go find a spot. In the second round, after we've gathered data from the first round, we'll be able to see, did that open destination concept populate the map in a way that provides fair access around the state? Did it over-concentrate in areas around the state? And depending on that data that we get back in round 2, it'll be a little more prescribed destination idea where we then will put the destinations in more access-friendly and less concentrated around the first tranche, if you will. And that will be, again, based on their rank in the lottery, so that at the end of the day, we've combined sort of an open market and a more prescribed lottery in a way that gives us fair distribution of those 10B licenses.
Andrew, how do you keep the process moving so people don't have to wait in line to select their location, and you have this phase 1 and this phase 2 that comes after? How do we go about that?
Yeah, so the design that we're coming up with has this phase 1 stretch over a period of time, but that phase 1 is going to be broken up into smaller chunks where we're going to publish the locations that have been selected. Ideal would be a real-time map, but we want to provide at least some flexibility for us to process any of these applications, determine if they meet the requirements surrounding the statutory objectors or other dispensaries that have already put their pin in the map, so to speak. And each of those time gates are going to then sort of close the application period at that point. If you get through the gate, You put your pin down and you're good, that's your spot. You can pick that spot and start working towards getting that license up and running in that location. If you missed that gate, or if there was a conflict and you got lower ranked in the lottery, you're going to be moved into the next group where you will then get another chance to put these pin in. But these will be very quick chunks where it's not going to take weeks for us to process. It might be, a couple of times a week we make these publications. This should get through phase 1 very quickly as people have selected their sites, they know where they're going to operate, and they know where they're going to be. Then we can use the data from that point to set up phase 2 and make sure that we're achieving equal distribution.
And let me just be a little more, provide a little more visual clarity to it. So there's got to be a time gate where we say off to the races in this first phase. That'll be a time gate, it'll be announced, and then it'll come down. And what we're contemplating at this point is a 3-day time period.
What happens if someone fails to select an appropriate site, or maybe a locality puts a moratorium in that hasn't been there up until that point after a licensee has selected a site?
Yeah, the rules that we wrote provide that if you're unable to select a site in that first phase and you were qualified to do so, you'll move into the second phase. So the license they get eliminated, it doesn't go away. They just end up in the spot where the state is more prescribing where some of these locations might go. That's the process that we've outlined right now, and I think that will work to incentivize people to find these locations and get themselves in that first phase before it gets to phase 2.
We're going to talk a little more about site location applications coming up in the next segment, so thanks guys. When we come back, we'll talk about that. We'll also talk about next steps and how the General Assembly could weigh in.
It's your money, come and claim it. The Ohio Department of Commerce Division of Unclaimed Funds is currently safeguarding more than $3 billion in unclaimed funds. So there's a good chance you or someone you know has money waiting to be claimed. Just head over to our website, unclaimedfunds.ohio.gov, to search your name, the name of a family member, or a loved one to see if you have an unclaimed fund.
So speaking of phase 1 and phase 2, a couple questions about that. I'm curious when phase 1 starts and ends.
Let me just preface this answer with our objective is in expeditious, short order to open the starting gate in phase 1, that open destination with some limitation phase, and close it expeditiously enough for these businesses to break ground, get started, get done, and have no worries about the site that they picked. At the end of that, if that phase 1 goes as we expect, it should be a matter of days, maybe a couple of weeks before it closes, before we can get into the second phase, which is that more prescribed map. But when that opening gate in phase 1 comes up is really a function of an official process that we have to go through, which is CSI and JCAR, before we can start that process. And I'll flip it to Andrew to talk about that a little bit more.
Yeah, so we can't issue these applications until the rules for the applications have been published and accepted and moved all the way through the process. That's why we want to put this in the very first rules package that we're doing in order to expedite this site selection and get everybody going and off the ground. But the CSI and JCAR process takes time. It's very prescribed in how long it might take. The normal that you see is somewhere between 50 and 90 days. We hope that we are going to be able to get through the CSI process as quickly as possible so that we can start working on these sites and the applications themselves.
Will the social equity licenses also be subject to the 1-mile restriction that comes out of site locations and where you need to be?
So the rules that we wrote now are only referring to the 10B license selection process. The social equity licenses that will be granted later are going to be in conjunction with the Department of Development. We would expect the Department of Development to make some recommendations as to what would be appropriate in terms of spacing or in terms of location, how the social equity licenses should be distributed under those circumstances. And we look forward, I think, to working with them to develop whatever criteria might be necessary.
When do you expect applications to be live on our website or through some portal that we'll have?
At the very latest, that will be June 7th of 2024. But if we are able to get through the process quicker, then we are ready to roll then too.
What we're aiming for is, notwithstanding the June 7th date, is to be looking in the rearview mirror about all of the expectations and requirements so that stakeholders can make plans and carry on with their business in a very efficient way.
The General Assembly has yet to pass anything related to recreational marijuana. How do these proposed rules take that current reality as we sit here in early February 2024 into account?
So, in a perfect world, we, like in terms of rearview mirrors, in a perfect world, the General Assembly has put their imprimatur on the facets that they feel important. And that's given to the regulator as part of the game board to figure out these rules. That's the ideal situation. That ideal situation was not handed to us because they have not given us any sort of changes, suggestions, proposals to initiated statute. So in the absence of that, what we are doing is getting as much stakeholder feedback as we can, proposing what we think is fair, efficient, and expeditious, and hoping that with all of the feedback that we get, we propose something that industry wants, that we want as a regulator, which is a win-win, and that the legislator reacts accordingly and its refinements to what we're proposing.
When can we expect the next set of proposed rules, and what might they cover?
So we're targeting March 1st for the release of the next set of rules, and we expect that to be very heavy on the way that a dispensary will have to operate. So this will cover security requirements, the way that patients or customers will be able to interact with the system, as well as some more general pieces about how marijuana moves through the production chain from cultivators to processors to dispensaries.
And how will the public and really the stakeholders continue to be involved in this process?
Well, like they have been thus far, which is text, email, phone call, carrier pigeon, skywriting, and all the rest of any way you can communicate to us, we're taking feedback.
We really are very open to all of it and want it. So gentlemen, thank you so much for joining us today and uncomplicating some of this, because there is a lot to it, and I'm sure we'll be having another conversation. We continue to update our frequently asked questions document with information about this rules package and everything else related to non-medical cannabis. You can find it at com.ohio.gov/non-medical cannabis. That's com.ohio.gov/non-medical cannabis. Thanks for joining us for Protecting What Matters. Make sure to check out our other episodes filled with great information for consumers and businesses alike. I'm Michaela Hunt, and we hope you'll tune in again soon.